This is an application and appeal in the matter of Ofori-Addo and London Borough of Haringey.
Yes, Miss Murray.
My lord, my lady, if it please the court, I appear on behalf of the appellant, Miss Ofori-Addo. My learned friend, Mr. Mullins, appears on behalf of the respondent local authority.
Miss Murray, I've got some bad news for you. My hearing is not very good. I would be very grateful if you'd crank up the volume.
My lord, yes.
That's fine. You can keep it there. I would be very grateful.
Thank you, my lord. Mr. Mullins appears on behalf of the respondent local authority. I understand that my lords have, from both my learned friend and I, perfected skeleton arguments. The court should also have a bundle of authorities which is sidelined, as well as a core and a supplementary bundle. I understand my learned friend wants to make an application to adduce additional documents to the supplementary bundle. The supplementary bundle should run to page 104. I understand that the court has copies of that. In short, my lords, my lady, the application is not opposed. We reserve our position on costs. However, the contents of the application is not opposed.
All right, let's take in stages. Then we have now a supplementary bundle which runs to pages 104. We have an additional small bundle. There was an application notice and I said the application should be made today. You don't oppose it?
Yes, my lady.
Right, thank you very much indeed. Insofar as the core bundle is concerned, we have, in our core bundle, we have two skeleton arguments from you. We have your skeleton argument and then a replacement skeleton argument. And insofar as the respondent is concerned, I'm not aware that when you say there's a perfected skeleton argument from the respondent, I have a document where you're including all the references to the core bundle, the supplementary bundle.
That's it, my
I thought it was too. Can I just say we have received this morning another perfected skeleton argument from you?
That's my only perfected skeleton argument, my lady.
Right.
I guess they handed up a hard copy in case the electronic copy didn't reach the court.
Where was it sent?
Yesterday. Rather late, I do apologise, my lord.
All right.
It's a bit like the sidelining of the authorities.
Yes.
By the time the sidelining of the authorities came in, I think I'd sidelined the authorities. So if at all possible, these things should give the judges at least some chance of getting on top of them.
My lord, thank you.
Can I just say this? I just want to double check this because in my core bundle, I have what is described as a skeleton argument on behalf of the appellant, and that is dated the 13th of December 2024. It's from yourself, Miss Murray.
Yes, my lady.
Right. Then this morning we received the perfected skeleton argument, which is dated also the 13th of December 2024, but it's not an identical document.
It should be an identical document, save for the addition of the references which are in bold to the three bundles.
Well, that's what it would appear to be.
Except in my bundling, under tab 3, which is what I thought was your main skeleton, or your skeleton for today, there was a skeleton with 70 paragraphs, and the document we've got this morning has got 90 paragraphs, and I'm not aware of an interim document, which is probably my fault, but I just consciously. Anyway, what you would like us to be paying attention to is a document dated the 13th of December 2024 with 90 paragraphs and page references.
My lord, yes.
Okay.
Which is the document we received this morning.
Yes, my lady.
This is not satisfactory, Miss Murray.
I apologise, my lady. It should be identical to the one at page 19. The two additional paragraphs I can't explain at the moment. I can take instructions about it. There must have been a confusion in terms of the
Sorry, isn't it the same as the document at page 36
Yes.
in the bundle, not the document at page 19? The document at page 19, as my Lord Justice Stuart-Smith said, is a 70-page skeleton.
Yeah,
There's
quite
then
right.
a replacement skeleton which appears at page 36,
Quite
which
right.
runs to 90 paragraphs. And as I understood it, your perfected skeleton replaces the document at page 36, not 19.
That would make more sense, my lord.
Yeah.
Thank you.
So your perfected, the one we've got this morning, is identical to page 36, except that it's got the references.
Yes, my lord.
Thank you.
And they both have the same date, which is the date I gave.
Yes. Yes.
Right. Are there any more matters of housekeeping that we need to deal with before we turn to the appeal itself?
Not from my perspective, my lady.
My lady, no, assuming that the additional documents that went into the amended supplementary bundle are before the court and there's no issue with that, then no, nothing from us.
Well, can I just say this? In respect of the supplementary bundle, there was originally a bundle which went to page 79. Then there was a new bundle which carried on then to page 104. And then there is the much smaller bundle which begins with a letter dated the 26th of September 2021 and concludes with emails which are in May 2023.
My lady, yes. So what happened is, as the court could see, that the timetable under the practice direction went slightly awry with this appeal because there was, and I think it was agreed, a late filing of their replacement skeleton argument, which is then what triggered the deadline for our skeleton, and the Christmas period came in the middle of that. So my solicitor agreed the index to the supplementary bundle before my skeleton argument in response to Miss Murray's skeleton argument had been filed. Once I had completed my skeleton argument, I identified in the process of doing that there were a number of documents that should have been in the supplementary bundle that weren't.
So is that.
Which is those documents.
That's explained in the application,
It
is
is.
Thank you. Right, are we ready to start?
My lady, yes.
Good. Yes.
This appeal arises from an appeal under Section 204 of the Housing Act 1996. That appeal was heard in the County Court and was dismissed on all grounds by His Honour Judge Saggerson on the 10th of October 2023. The decision that was challenged in that appeal was made by the Respondent Local Authority under Section 202 of the Housing Act 1996. In this appeal, we ask the court to determine what it means for the local authority to discharge the obligation given by Section 184 of the Housing Act 1996 that is upon a local authority when they are determining an application for homelessness assistance under Part 7 of the Housing Act 1996. My submissions will follow the structure of my skeleton argument. I propose first to take the court through the documents in the supplementary bundle, which will give a sense of the chronology in this appeal. And I anticipate that taking approximately 40 minutes. And then I'll move on to the authorities, which should take me just over an hour. My lords, turning to the supplementary bundle. By way of introduction to the facts of this matter.
We have read the papers.
Thank you, my lady. I'm grateful for the indication. Just by way of background and to give a sense of the chronology then, at page 1 of the supplementary bundle, when this application began, the appellant, Miss Ofori-Addo, sought homelessness assistance. She was leaving accommodation known as Wren Court, and she was offered interim accommodation by the respondent by the letter which appears at page 1 of the supplementary bundle. by this letter, the local authority agreed to provide to the appellant interim accommodation. They say in the letter that it would be at Broadwater Lodge. This is dated 26th of the 7th, 2021.
And she went there.
She accepted the offer and took up the occupation in Broadwater Lodge, that's right, from the beginning, my lord, of this application process.
And she went with both her sons.
With both her sons. Miss Ofori-Addo is a single mother to two sons, both of whom have autistic spectrum disorder and other mental and physical health conditions. It's not an issue between the parties that the two boys are disabled. At page 2 of the supplementary bundle, some details are given of the children.
Yes, but as I say, we have read it.
Thank you, my lady. Whilst Miss Ofori-Addo was residing at Broadwater Lodge, she was under the interim accommodation duty, which is given by section 188 of the Housing Act 1996. At the top of the letter on page 1, the local authority refers to the test which has been satisfied to give her that offer of accommodation. The local authority had reason to believe that she was homeless, eligible for assistance, and had a priority need of housing. So there she resided. Subsequent to that, on the 13th of September 2021, a local authority made a final offer of accommodation, and that is contained in a letter at page 4 of the supplementary bundle.
Well, it begins here, doesn't it? You have been approved by the council for a final accommodation offer.
Yes, and that offer was made by that letter. Mm-hmm. So that's dated the 13th of September 2021. Then subsequently to that,
Okay, and that remains the important offer throughout, which she refuses.
That's the relevant offer.
Yeah, although she's advised to accept and question if she wants to, she refuses, as we see in the documents.
She refuses, yes.
On grounds of suitability.
She refuses on grounds of suitability. She refuses on grounds of suitability because of the children's need to exercise, in essence, my lord. It's, as the judge found at the hearing below, the property is officially a 3-bedroom property, but 2 bedrooms have been divided. 1 bedroom has been divided.
But the important thing for us is she refuses the offer because of suitability.
My lord, yes.
She asks for a review of suitability. And that's the process that we see working our way through to 2023.
Yes, she asks for a review of suitability. That's true. Suitability and duty are, in my submission, inherently linked in this case, as I'll make clear when I take the court through the statutory provisions. But certainly in this case, there's a disapplication which arises of the main housing duty by the function of section 193 capital A. That disapplication is premised on suitability. So when you request a review of suitability, you're also requesting a review which is linked as to the significance of duty.
Okay, you're going to have to explain that, at least to me, because of subsection 2 and 3, which make clear simply that those duties go if a review is negative.
If a review of suitability upholds the local authority's decision, then the main housing duty doesn't apply.
Yeah.
Yes. So the disapplication of the main housing duty is always premised on suitability.
And the relief duty goes as well.
The relief duty goes as well.
So 2 duties go.
Yes. So duty and suitability are in this particular factual scenario linked.
Well, you say they're linked. That ultimately may be a matter of interpretation, but as a matter of fact, the review that was sought was on the basis of suitability.
Initially, it was on the basis of suitability, yes.
What do you mean by initially?
Well, I was hoping to make good this point by drawing the court's attention to the chronology, but this series of correspondence in 2021 was essentially the first review process. There was then an appeal to the county court. In the grounds of appeal to the county court, ground 3 raised duty specifically. What, if any, duty is owed? The grounds of appeal specifically said that it was an error of law to have failed to consider what, if any, other duties arose. Now, that skeleton argument is within the bundle. It is the skeleton argument of the appellant in the first appeal. It's at page 67. It's dated as well.
Is that core bundle 67?
It's supplementary bundle 67.
Thank you.
And on supplementary bundle page 79, it is signed and dated the 15th of September 2022. That was in advance of the appeal, the first appeal hearing that was listed for February 2023. The respondent authority came to that appeal hearing knowing that duty was being raised by ground 3. They compromised that appeal and said they would conduct a fresh review. Okay. So when they undertook that fresh, if duty wasn't an issue in the first set of correspondence in 2021, it most definitely was an issue in the second set of correspondence, which post-date that appeal hearing that was compromised in February 2023.
You'll take us to those documents.
Yes. We don't have the document settling the appeal, but it's uncontroversial, accepted between the parties that a fresh review was agreed to be
The appeal
done.
was withdrawn, wasn't it?
The review decision was withdrawn and it was to be remade. Yes. So given that ground 3 raised duty very specifically, and that document's dated 15th of September 2022, it doesn't matter, I say, that the first set of discussions about the review, so representations on review and determinations on review in 2021, focused on suitability. My primary submission is that they oughtn't to have done because suitability and duty are inevitably linked. But my secondary position is, even if it was only about suitability, as it were, in 2021, it certainly wasn't only about suitability after the point where the local authority agreed to conduct a fresh review. Duty was firmly an issue.
All right, well, you're going to take us to the relevant documents.
Yes, my lady. So we were up to the offer letter, which is the 13th of September 2021. That's at page 4. After that, in the bundle at page 8, the supplementary bundle, is a notice that our relief duty has come to an end. The title to that is section 193 capital A, notice that our relief duty has come to an end. Although that letter's undated, it's referred to in both my learned friend and I as skeleton arguments as the letter of the 24th of September. It appears to be established that that was its date. The reasoning refers to the letter of on the 13th of September, so I'm at paragraph 4 under the bold heading. On the 13th of September 2021, the council made you a final accommodation offer. However, you chose to refuse this offer despite being made aware of the consequences of doing so. And then the document goes on to explain that the relief duty has ended. And the decision maker says, I'm satisfied that the relief duty has come to an end as section 189B9A applies to you. I've considered all the relevant facts. And then there's a bullet point list of all the relevant facts and documents that's been considered. In order for our local authority to be able to end its duty towards you, we must have advised you that this was a final accommodation offer. We must also be satisfied that this was a suitable offer, and we warned you of the consequences of refusing the offer.
But there was no challenge to this letter, was there?
Yes. Yes, all the representations that followed were concerning both suitability and duty, not only because they're linked by the statute, but also as a matter of practicality. This letter was the subject of the subsequent challenge. The penultimate paragraph provides as follows: I'm therefore satisfied that the duty to help or provide you with accommodation has come to an end. This is because not only has the relief duty come to an end, but that section 193 main duty does not apply. This means that you will not receive any other offers, and the council will now take steps to evict you from any temporary accommodation you may be occupying. So that was the letter of the 24th of September. And that's explained and summarised in paragraph 21 of my skeleton argument. Next, and in response, on the 7th of October 21 and the 8th of December 21, requests for a review and written submissions were made. And then in response to those submissions...
So can we just go to...
The first page.
Yeah.
The pages of the review requests?
Yes.
One is the 7th of October, and that's at page 83.
My lords, my ladies, just because we're on the facts, on page 80, I think the first review request comes in 22nd of September 21. Yeah. That's on page 80, which predates the...
And that's, we've got that in the core bundle and at page 80 of the supplementary.
My lord, yes.
So it's tab 10 of the core bundle, isn't it?
Yes, the first request for review is on page 80, and then representations, page 80, I apologise, of the supplementary bundle.
And so if we look at page 80, it says, following a viewing of the property and upon inspection of the same, our client has raised several concerns as to suitability. It explains that in a short paragraph, and then it is for this reason that our client rejects the offer of accommodation at 17 Gretton Road on the grounds of suitability. We therefore request a review of your decision under section 2021H. Now that's the suitability provision, isn't it?
It is.
Yeah. In respect of the same. So there one has, in September of 2021, the request for a review on the grounds of suitability under the relevant section of the Housing Act.
My lady, yes.
Right?
Well, but it's not a challenge to duty.
No.
Not expressly, but implicitly it is. And in any event, it is the responsibility of the local authority to review duty.
But if the review came to the conclusion that the property was unsuitable,
yes,
which is what the review was asked to find, then there would be no question that the authority would still be under the duty to find suitable accommodation. But it's not a sort of freewheeling challenge to duties. The only reference to duty, as I've understood it, is at the last paragraph of 81, which says, we do wish to highlight, pursuant to section 188(2)(a), where the review concerns suitability of a final accommodation offer, the interim duty continues until the review is concluded. That's the only statement about duty at all, isn't it?
Well, it is, my lord, but it is the only express reference to the 1H provision under section 202, which is specifically about suitability. However, it remains the responsibility of the local authority to determine what, if any, duty applies under the part. It is not for the appellant to spell out to the local authority that they
must
must
not an issue.
determine.
I'm very sorry, I'm obviously being very slow about this. It's not an issue. They're saying, we are rejecting this offer because the property is unsuitable, full stop. and we're rejecting it, and we're asking for a view under H, which is all to do with suitability. And B is the appropriate one if you're challenging an error as to duty, I think, B or C. So what we've got here so far, I mean, it may change as we go forward, but what we've got at the moment is something which says this property is not suitable and says nothing about duty, because it's obvious that if the property is suitable, things are going ahead. If the property is unsuitable, then the authority's got to try again. So what am I missing?
Well, my lord, the first sentence of the letter says the Miss Socrates Ofori-Addo final accommodation under section 193 capital A4, but that is the very statutory provision which links the suitability of the final offer of accommodation to duty. Section 193 capital A is the disapplication of the main housing duty by virtue of a suitable offer of final accommodation having been made.
Yeah.
So it is always, because of the reference to that disapplication provision, the link is clear, I say.
You say, yeah.
That's our case.
What about that heading? Because you were dealing with it there, that heading in bold at the top of page 80. The final line of that is request for review under section 2021H of the Housing Act 1996. That is suitability.
It is suitability, but because of the amendments made by the Homelessness Reduction Act, in this particular circumstance, suitability is inherently linked to duty in these cases.
I'm sorry to keep going on this, but by the sound of things, I'm not necessarily the only one who hasn't quite understood the thrust of your argument. You refer to section 193A, subsection 4. That is simply the section which defines what a final offer is.
Yes.
And then it doesn't say anything otherwise about duty, although obviously if you reject a final offer under the statute, certain consequences follow. But I don't, at the moment, if you are submitting that this was a challenge to the decision on the issue of duty, you've still got some work to do to persuade me, because I don't understand the submission.
Although the letter does refer to the subparagraph 4, if my lord goes to that section 193 capital A, which is at page 24 of the authorities, 4 just defines a final offer of accommodation. My lord, absolutely, that's correct. But it wouldn't make any sense unless it's read with the other sections. Section 193 capital A, the heading of this section is consequence of refusal of a final offer or a final part 6 offer at the initial relief stage. And then it goes on to explain the reason it's defining a final offer is that rejecting such would have enormous consequences. For instance, subparagraph 2, the authority's duty to the applicant under the relief duty, section 189 capital B2 comes to an end, and subparagraph 3, section 193, the main housing duty does not apply. So in challenging the suitability of an offer under subparagraph 4, it is implicit, and indeed it is necessary for the local authority to consider duty, because they're inherently linked by this section. I think that's as far as I can advance that submission at this stage in the chronology.
Okay.
As I outlined earlier, my secondary position will be that even if it wasn't an issue now, it certainly was an issue after the local authority undertook to perform a fresh review. have one more submission to make about that particular document, which we just looked at page 80, the initial request for a review in the supplementary bundle. Over the page at page 81, the link to duty is again highlighted by the solicitor making this request for a review. At the final paragraph, the solicitor says, in respect of the above, we do have a wish to highlight, pursuant to section 188(2)A, which is the interim accommodation duty provision, where the review concerns suitability of a final accommodation offer made under the relief duty, as is the case here, the interim duty will continue until the review is concluded and our client has been notified of the outcome. So there's another duty which is potentially linked here.
It's not an issue.
Yeah.
Is it? I mean, no one has suggested that the council has acted in, or the authority has acted in breach of its duty before the review is concluded and you were notified of the outcome.
No, that's right. But my point is that duty exists as an issue within this review, not merely as to the. It's not merely about suitability. There's much more that hangs from suitability in terms of what duty, if any, is owed under the part. So that's the initial request for a review, and that's made 22nd of September 2021. The other requests for review and review submissions, I've put the dates of those at paragraph 22 of my skeleton argument. The first is the 7th of October.
That's beginning at page 83.
Yes.
And that again has section 202 suitability review of section 1934 accommodation.
That's right.
And that again deals with the issue of suitability.
My lady, I agree. Its focus is on suitability, but our case is that duty was inherently linked.
Well, if you look at page 88, where one sees in the substance of the intervening pages, different points are made. And then you have, at the end of paragraph 13, we ask that you consider the points raised above when reviewing the suitability of the offered final accommodation. One might say it's quite clear.
Yes, again, I concede that the focus, the thrust of this request for a review is suitability.
It's not the thrust, it is the specific request.
The same points, almost identical points, can be made of the letter that's at page 90, the 8th of December 2021, further representation, section 202. Again, the points that are raised focus on suitability. But I hope to show by reference to the authorities that it isn't incumbent on the applicant to define the scope of the review. And indeed, even if they wanted to limit the scope of the review to one issue or another, they wouldn't be able to. It is instead, it's incumbent on the local authority to consider what duties, if any, are owed.
So, forgive me for just not necessarily understanding that. Where the section gives A to H, different thing, is it your submission that if someone asks for a review, it doesn't matter which subsection they identify, they automatically generate a generalised review of all aspects of the decision?
That's my primary position, yes, my lord. I say this.
Is that based on, I think it's Lord Justice Lewison saying when they review their decision, they review the duty?
Well, Tamor is certainly, I say, authority for that proposition. But also in the case of, there's another authority which I'll take my lord to, which I say makes the same point, as well as which my primary position is that section 184 provides a duty for a local authority to do exactly that. It must consider what duties, if any, are owed under the part. And indeed, in the case of Ahmed, which is referred to right at the start of my skeleton argument, Lord Justice Newey, in that case at paragraph 62, approved an approach taken by the local authority in that case, where all that was required for the local authority to do to discharge that section 184 subparagraph 3 obligation was to use a subheading saying section 184 decision and to say no other duties are owed under this part for the reasons that have already been stated above. It's not an onerous requirement, I say, but it must be done for the sake of completeness, because to omit it could be potentially highly significant, and in this case, I say was highly significant for Miss Ofori-Addo.
And am I right in thinking that a decision under section 184 only needs to be notified if it's adverse to the applicant?
Yes, that's the way section 184 reads. Yes, my lord.
Thank you.
So I was at paragraph 22 of my skeleton argument. So the two sets of representations were made. The court has my submissions on what they signified and what was required of the local authority at that point.
Which paragraph of your skeleton, sorry?
That was paragraph 22. I
Thank you.
state the two dates of the sets of submissions that are now in the supplementary bundle. Subsequently to that, in terms of the chronology, the respondent wrote what's known as a minded to letter dated the 7th of January 2022. That's at page 10. Page 10, my lady, of the supplementary bundle. My primary submission on this document is it's clear from the face of it that what's being considered is duty as well as suitability, regardless of what the submissions focused on, and I concede they focused on suitability. Here, what's being reconsidered by the local authority is duty. It's not to say they're doing it necessarily correctly, lawfully, or completely, but they are turning their mind, as it were, to duty. We can see that from the first page, the reference to section 189B, which is the relief duty, and section 193 capital A, which is the provision which links, which creates the disapplication of the main housing duty when there's been a rejection of a final offer of accommodation. So over the page, and then on page 11, the second sentence, I must therefore uphold the council's decision given in the decision letter of the 24th of September 2021, that's the undated one, that the council does not have any further duty towards you. Duty is being reviewed.
This is the minded letter, isn't it?
This is the minded to letter, yes. So this is the letter which gives the applicant the opportunity to refute the provisional conclusions of the respondent, of the local authority. In reaching my conclusion, I've taken into account all the information held on file, and in particular the following. And there's an enormous list of documents there relating mainly to suitability, but clearly what's been accepted at this point in the review.
But do any of them relate to anything other than suitability?
It's difficult to say that they expressly do, but similarly, it's my submission that they needn't. The local authority has accepted that it must review suitability, that it must review duty alongside suitability. Suitability is again expressly considered at page 12, and there is engagement with the reasons why the applicant is refusing the accommodation. And that consideration goes on over several pages. I said the main issue was room for exercise. That's considered at page 15. I said it was established that it was agreed that the children were disabled. That's again at the bottom of page 15.
Forgive me, you're dropping your voice.
Oh, I apologise, my lord. I was just making good on the point that the children were accepted as being disabled. That's paragraph 21 of the decision letter, page 15. over the page, however, ending of duty is a subheading that's used on page 16 above paragraph 23. And the local authority reasons that in order for the council to be able to end its duty towards you, they must have informed you of the consequences of refusal or acceptance of the accommodation which they are satisfied is suitable and notified you of the right to request a review of the suitability of the accommodation. It's evident they complied with the above requirement in their letter of the 13th of September. Despite this, you failed to accept the offer. And the reasoning goes on until paragraph 26 is the conclusion. I'm therefore satisfied that the duty to help provide you with accommodation has come to an end. This is because not only has the relief duty come to an end, but also the main duty does not apply. This means that you will not receive any other offers and the council will take steps to evict you from any interim accommodation you may currently be occupying. So although what drove the review initially was suitability, what's plainly being considered here is duty. The error, I say, in paragraph 26 is that the two are being collapsed. It is correct that section 193 capital A provides for a disapplication of the relief duty and the main housing duty. Indeed, we've just looked at it. It's subparagraph 2 and subparagraph 3 of that section. But what it doesn't say anything about is all of the other duties that potentially arise under Part 7.
What are the other duties?
For instance, there's a duty to the intentionally homeless.
Which is what?
To provide short-term accommodation. In fact, we can look at it if that would assist. It's given by section 190 and it's in the authorities bundle at page 13.
Yeah. Can we get a list before we go to the details? Does not mention duty to intentionally homeless.
Yes, there's a duty to the intentionally homeless. There's potentially an extended interim accommodation duty, which we've already looked at. And
extended interim accommodation duty.
And those are the only ones which are relevant on these facts, potentially.
So I missed in relation to section 190, is it simply the duty to offer advice and assistance?
No, if my lord looks at page 13, it's subparagraph 2, the authority must secure that accommodation is available for his occupation for such period as they consider will give him a reasonable opportunity of securing accommodation for his occupation and provide him with, or secure that he is provided with, advice and assistance. So there is a short-term accommodation duty there as well.
What is the impact of that on that duty of a refusal of a properly constituted offer of accommodation?
Well, none is provided for by section 193 capital A. In other words, this duty still falls for consideration, even if the disapplication is in place.
You might come to it later, but how does that play out with the 189B duty coming to an end once the accommodation is refused under section 193 capital A?
Does my lord mean if you're evicted from accommodation you're occupying?
You're intentionally homeless because you've refused accommodation which a local authority considers to be suitable, and the duty comes to an end under section 189B, does it not?
Yes.
So how does that play out with section 190 subsection 2 then? Because here, under section 190 subsection 2, you're saying that, I think you're saying, but I may have misunderstood it, that in this particular case, your client was intentionally homeless and therefore the local authority owed her a duty under section 190 subsection 2 that seems different from what has happened under section 193A, which meant that the relief duty has now come to an end.
And that, my lord, is their error. If you follow the disapplication 193 capital A, then the relief duty ends and the main housing duty doesn't apply, and you are evicted from relief duty accommodation.
Yes.
And that's what happened. Now, after that, after having evicted her, the local authority wrote her a letter intimating, although not concluding in any definitive terms, that she'd made herself intentionally homeless. Now, that was another duty which fell for consideration. Outside of the disapplication, it could still apply. And it could still be owed. And if the local authority considered on the facts, we say you've made yourself intentionally homeless because you refused a final offer and we've evicted you from relief duty accommodation. However, we've decided that you didn't make yourself intentionally homeless for whatever reason, and therefore the duty is not owed. That's a duty adverse to her interests for the purposes of section 184, and it requires reasons and it must be notified to her in writing. Alternatively, they could say the same factual scenario applies, but we've decided we do owe you the duty under section 190, and we're going to provide accommodation to you under section 192 on a very short-term basis. We'd have determined that a reasonable period for providing that accommodation is, say, 6 weeks, or we've taken into account that your children are both under a disability, so we've decided a reasonable period is 8 weeks. And the Code of Guidance stipulates that the local authority must take into account the contents of the personal housing plan, which has been agreed with the applicant, when they are determining what would be a reasonable period for them to accommodate a person who had been found to be intentionally homeless. It's not my case that they should have provided necessarily that accommodation or that they should have decided that in any particular way, but on the facts, having written to her and said that she was intentionally homeless, it fell for consideration. Did the duty apply under section 190 or did it not? Whatever the decision, it fell for consideration. So we looked at page 17 at the, sorry, we went up to page 16, I apologise.
Forgive me, I'm going to have to remember this after we've parted company. If what your submission, as I understand it, is if the local authority conclude that she's intentionally homeless, it still falls for consideration whether the duty to the intentionally homeless was accepted or not, and if not, why not?
Yes, my lord.
You say that is a necessary and integral part of a decision where you have a letter, so you have a review decision like this, rejecting the allegation of suitability, because, as I understand your submission, the consequence of that rejection puts you into at least the area of being intentionally homeless, and the local authority has to decide how they're going to treat her as an intentionally homeless person who would otherwise have priority needs.
My lord, yes.
Is that the case?
Yes.
That's it. I mean, I'm sure you've got other things to say, but is that the nub of your submission?
Essentially, yes. Yes.
Okay.
The disapplication by section 193 capital A says nothing about the duty to the intentionally homeless, so it must still fall for consideration. A local authority needs to consider whether they owe the duty under section 190 to a person that has, as my lord said, refused an offer of final accommodation and is being evicted.
If they accepted the duty to the intentionally homeless, that wouldn't be a decision adverse to her interests, would it?
Not necessarily, but if they accepted that the duty applied to the intentionally homeless, they would still need to write a letter saying what that reasonable period was for her to occupy accommodation, and they would need to provide advice and assistance. We just looked at section 190. The provisions there are 2A, secure that accommodation is available for such periods as they consider will give him a reasonable opportunity of securing accommodation. Well, it's got to be reasoned. There's been some indication in the case law that a 28-day period would be reasonable. It would depend entirely on the facts as to how quickly a person would be able to, an applicant would be able to identify and secure accommodation for themselves and whoever was reasonably expected to reside with them. But also as a matter of practicality, in order to give effect to 2B, to provide him with advice and assistance, it would need to be in letter form, and indeed it would need to engage with what accommodation was available in the area and how it might be accessed. Indeed, that's what's said at subparagraph 5. The advice and assistance provided under subsection 2B must include information about the likely availability in the authority's district of types of accommodation appropriate to the applicant's housing needs, including in particular the location and sources of such types of accommodation.
Sorry, where are you reading?
Oh, I apologise, my lord. That's page 13 of of the authorities bundle. It's subparagraph 5.
Subsection 5.
Yes, my lord.
Thank you. And that isn't covered by the statutory impact of removing the general housing obligation.
That's right, my lord.
Okay.
The disapplication just doesn't operate on section 190.
Says nothing about homelessness. Is there any other duty that we need to be considering?
On our facts, there's really only the section 190 duty and potentially the 188 duty, which is the extended interim accommodation duty. But it's the 190 duty which is particularly significant, and I will say meaningful. So I wouldn't labour any other duty particularly unless my lord has one in mind. We looked at the Regulation 7 letter, which is at page 10. That's the letter that I described in paragraph 26 of my skeleton argument, and I said that at page 16 they uphold their decision to end the duty, but that what they've done is made an incomplete decision as to duty because they haven't gone on to consider what, if any, other duties apply, notwithstanding this application, which is in operation because of section 193 capital A.
I'm very sorry to be so slow. Where are you?
I'm at page 16 of the supplementary bundle.
And I'm even slow because I just wanted to pick up with you one other question arising from your comments about section 190. And I'm sure you're going to be able to place your finger on this straight away and help me. But where in the statute would I find some help in relation to whether or not your client was homeless intentionally as a consequence of her refusal to accept the suitable accommodation? It may be that is such a blindingly obvious point that it doesn't need making, but perhaps you could just make that point for me, if you don't mind.
The test for intentional homelessness, my lord, that's section 191, becoming homeless intentionally. It's at page 15.
Fine. Well, I don't need to take you to it now. We can have a look at it later if it's... Thank you.
So, Miss Murray, dealing with this letter of the 7th of January, the substance of the letter is all directed to the issue of suitability. It deals with facts, and then I'm satisfied the accommodation was suitable. It deals with each of the sons. It deals with the medical issues relating to the appellant. All of it directed to suitability. And then one comes at page 16 to ending of duty. And is it particularly paragraph 26 that you are referring the court to, so that we understand?
It is, my lady. So, so paragraphs 23 through to 26. That is, it demonstrates that the local authority was considering duty, but it also shows that they weren't going far enough in the appellant's case.
I mean, it comes to this, that everything in this letter is directed to considering the issue of suitability, and one sees it there again in paragraph 23. And then really at 26, it's identifying the ending of duties.
It's identifying the ending of the main housing duty, but it's not considering what other duties are owed.
No, I've got that, but what I'm saying is that's what that paragraph 26 does.
Yes.
So I think this might be important in light of your last answer. You are not saying that, certainly as formulated at 26, this is a refusal of any duty owed to your client as an intentionally homeless person.
I'm saying they failed to consider
Failed to consider.
the intentional
Simply
homeless
doesn't
duty.
deal.
Doesn't deal with it. And should, because the local authority is obliged to consider what, if any, duties are owed under the part.
Not that it is a decision that duty does not apply.
Not that the intention, it's not a decision that the duty under section 190 doesn't apply, no.
The intentionally homeless, but yeah, okay.
Moving on then to the next letter from the respondents. It's dated the 20th of January 2022. It's at page 17 of the supplementary bundle. It opens with, again, a reference to that undated document of the 24th of September 2021, where the local authority made a decision that the relief duty had come to an end on the basis you refused a final offer and you requested a review of this decision. And then over at page 18, duty is considered at the top of the page. And the conclusion of that subsection is, I must therefore uphold the council's decision given in the decision letter of the 24th of September that the council does not have any further duty towards you. But we saw in the letter of the 24th of September, just as in the Minded To letter, there's been no consideration of other duties. It's only been the relationship between suitability, relief duty, and main housing duty that's been considered. No other duties have been considered. So to conclude here that the local authority is upholding a decision contained in the 24th of September letter that the council does not have any further duty towards you, it is incorrect. The decision letter of the 24th of September didn't reach that conclusion. And in any event, the contents of this letter are not considering what, if any, further duty. They are repeating the same error. They're only considering the relationship between the suitability of the final offer and the main housing duty, and omitting to consider what, if any, other duty applies.
But again, just picking up on where I was in my last question to you, this letter, which is superseded by the review decision that we're looking at, this letter deals with the main housing duty and the relief duty, but is silent as to any other duty.
Yes. there's a similar section now in this document, which there was in the Minded to Find document, with a subheading ending of duty. It starts at paragraph 29. It's at page 24. The same error that was at page 26 of the Minded to Find letter is repeated at paragraph 32 of this letter. Next, at page 26, the decision is taken to cancel the Broadwater Lodge interim accommodation, and at this page 26, there's an internal email asking from the decision maker to a cancellations team, asking for the accommodation to be terminated. They're saying the last date should be the 17th of February 2022. So this is on the 20th of January. That's the same date as the letter we just looked at. So not quite a month. Over the page then, at page 27, is a letter dated the 21st of January 2022. This is the next communication from the respondent to the appellant. In this letter, the request for interim accommodation pending a proposed appeal is being refused by the local authority. The local authority is saying they're not going to provide her any further accommodation. And this letter is significant because it intimates that she's made herself intentionally homeless. So there's a reference at page 28. It's almost the bottom paragraph. There's a little A and it says representations made in your letter dated 22nd of September 2021. And there's some engagement with representations that Miss Ofori-Addo had made as to why she should be provided further accommodation. That was refused, and in the final sentence the local authority says, once I concluded that the offer was suitable, this meant that the local authority owed no further duty to your client. That perfectly encapsulates the error of law, since that just isn't the case. Other further duties could apply, and indeed in many circumstances would apply, and certainly would fall for consideration.
Did you say that in this letter there's reference to her being intentionally homeless?
There is, my lord. It's over the page.
It's a little one at the top of that page. And little 3 on page 29, halfway down the page.
That's where I was going, little 3 on page 29. Yes, I'm satisfied that the decision under section 203, which found that your client was intentionally homeless, was correct. And find nothing in the claim which will affect the authority's review decision of the 20th of January 2022. And under personal circumstances, the second paragraph there, the reasoning in that second paragraph would seem to suggest that it was the fact that the suitability review had gone against her, and that the relief duty was being ended, and that she was being evicted from relief duty accommodation that was making her homeless. So the accommodation, it would seem that she's being told she has made herself intentionally homeless from, is the relief duty accommodation. That would appear to be, from the reasoning of the letter, the case. There's also some engagement in the next paragraph. So if that's the paragraph, the decision to find, the penultimate paragraph on page 29. And then the final paragraph on page 29 begins, I'm satisfied that. And the third sentence before the bottom of the page says, your client has also been given 28 days before having to leave her interim accommodation, which is a reasonable period of time to try and secure alternative accommodation. That wording echoes the wording we just looked at in section 190. So it sounds as though the local authority might be considering whether they are discharging their duty to the intentionally homeless, but they're not actually saying that she is intentionally homeless, or where from, or on what basis. And they aren't saying we have decided that this is a reasonable period. It's just an intimation. Strong enough suggestion, I say, to give rise to an obligation to consider expressly the duty under section 190. The reasoning, again, over the page at page 30, the fifth paragraph on that page, starts, the paragraph above shows that your client could have taken steps to prevent her and her two sons from being homeless.
Where are you?
Above little v, the balancing exercise.
Yep.
Those two paragraphs there.
Thank you.
And what about the paragraph under the heading balancing exercise, that first paragraph?
Yes, that's a repetition of the averment by the local authority that she's made herself intentionally homeless. They say that they've made a considered decision that she's intentionally homeless. But nowhere is the duty under section 190 either expressly accepted, discharged, or rejected with reasons. So moving on then to paragraph 31 of my skeleton argument, then chronologically speaking, it's only a month later, it's only a month after this decision where they say that she made herself intentionally homeless. It's only a month after that the first appellant's notice was filed on the 10th of February 2022. We don't have the appellant's notice in the bundle, but we do have the skeleton argument. I took my lords to it a moment ago. The reference for the court's note is supplementary bundle, page 67 to 79, skeleton argument, dated 15/9/22. It's ground 3, which raises duty in that first appeal. The appeal for which that skeleton argument was provided was listed for the 22nd of February 2023.
It's on page 67.
The skeleton argument.
Yeah,
Yes, my
and
lord.
the ground 3 that you referred to is set out at paragraph 2 of 2b of your skeleton on page 67.
Yes, although
They erred in concluding that by operation of section 190A2 and 3, no further duty arose following discharge of the relief duty.
yes, that's the argument that was
That's
raised
what
at the
you're-
first appeal.
That's what you're, I was going to say banging on about, but that's what you're pursuing.
My lord, yes.
I didn't mean it like that.
And that's raised in September 2022 in advance of the appeal hearing was listed for the 22nd of February 2023. On the day of the appeal hearing, it was compromised and the local authority undertook to perform a fresh review.
Okay, so we start again.
Yes. But this time, ground 3 has been ventilated. And the duty is squarely an issue, even if it wasn't before.
Okay, so there wasn't a new request for a review, was there?
No,
They just said, we'll go away and do it again.
they said, we'll do a fresh review.
So what they had was the representations which had been made for the original review,
Yes.
which, subject to the submissions you've made, are all about suitability, plus the fact that you have raised the issue of other duties by ground 3 of the challenge that you brought.
Yes. And in addition to those two points, she has now been evicted from interim accommodation that she was occupying under the relief duty, and they have written to her to say, you've made yourself intentionally homeless. From that accommodation, it would seem to.
And after she was evicted, did they in fact give her any support or assistance?
No. Not as far as I'm aware. She did undertake a period of sofa surfing, and I understand that she's now applied anew to the local authority. The latest update, she had applied anew, and she's been found homeless. The local authority has accepted that she is homeless still to this date.
That's November 24.
Yes, that's the letter within the bundle, November 24. That's right, my lord.
So.
But returning to the undertaking to perform a fresh review, that was at the end of the first.
Can you just pause a second, because I think this might be important and I might need to remember it. By the time review, no.
Can I just pick up on one point? My reading of the papers thus far indicates the compromise was effected at court because the respondents wanted to adduce further documents. There was objection to it, and so a compromise was effected whereby everyone would go away, the fresh documents no doubt could be considered, and a fresh decision would be made. Is that a fair understanding of the matter?
Very nearly, my lady. What happened prior to the February hearing was that the local authority made an application which was listed for the October, and the October prior to, so October 2022. And at that application hearing, that was an application by the local authority to adduce, as my lady identifies, further documentation showing, from memory, it was showing that the landlord was a proper person in the eyes of the local authority, and that was properly evidenced. At that hearing listed in October, the judge who was to deal with that application adjourns that application to the appeal hearing. His conclusion was it was more appropriately dealt with on the day of the appeal. So
it was never ruled on.
It was never ruled on. The documents were already seen, though, by both sides, but our position, the appellant's position at the October hearing, was that these were documents which went which went beyond what was permitted under the test for adducing further documents. And the test is that you can elucidate the reasons for a decision, but the evidence isn't supposed to advance entirely new reasons for a decision. So the application was opposed in the October, but both sides had seen the documents. It's true that the documents were known to both sides. Now, when it came to the February hearing, the compromise was to undertake a fresh review. It wasn't for the purpose of seeing the documents. The documents had already been seen, considered, and the application objected to, but adjourned in October.
So it went in front of the court effectively as a consent.
I didn't attend that hearing, but that's my understanding, yes.
Well, the withdrawal of the appeal and then a fresh review will be made.
Yes.
That would be the usual type of order.
Yes, yes. Then chronologically, the next significant piece of correspondence in the supplementary bundle was the letter dated the 26th of May 2023. I'm at paragraph 36 of my skeleton argument. This is at page 32 now. 26th of May 2023, page 32 of the supplementary bundle. The decision letter, this is a Regulation 7 letter. It begins in the same way that we've already seen in the previous correspondence. So the link between the relief duty, the final offer, requesting a review of the decision, that the relief duty has come to an end, and then engagement with the relief duty in the second paragraph.
My Lord's Melody, I'm sorry to rise to my feet. I was just checking because I have a feeling I was instructed in relation to that hearing but didn't. But I'm afraid the application was dismissed. So what led to the council's agreement to withdraw its review decision, make a new
Was
one.
the dismissal of the application?
I have the order here from the 22nd of February, and paragraph 1 of the order is the respondent's application dated 4th of October 22 is dismissed.
It would assist certainly me if you could just read out the terms of that order, please.
Certainly, my lady, I will. It's upon hearing Mr. Ian Colville, counsel for the appellant, Mr. Alex Campbell, counsel for the respondent, and upon the respondent having made an application dated the 4th of October 22 to adduce witness evidence from a review officer who took the Section 202 review decision being challenged, and upon the court hearing that application at the outset of the hearing and dismissing the application, and upon the respondent withdrawing the Section 202 review being challenged and agreeing to take a fresh review decision within 56 days, it is ordered that 1, the respondent's application dated 4th of October 22 is dismissed, the appeal is dismissed, and that the respondent pay the appellant's costs of the appeal.
Could we have that, please?
I'll extract. This is from the original bundle before the judge below. I don't know if the court. I know that was erroneously filed, but the court doesn't have it very well. I'll extract it and send it in.
Please.
The documents in question related to compliance with Article 3 of the suitability order. So documents that under that order, there's a tick box of things the local authority has to do to be properly satisfied a property is suitable. It was said that on that appeal, it was said that the local authority couldn't have been so satisfied because it hadn't got these documents on the file that had been disclosed. The local authority applied to say, oh yes, we did, here's a witness statement from the reviewing officer, and that application was dismissed.
So cutting to it, the application to adduce the further documents fails,
Yes.
and following that,
The local authority takes the view that it has no
Okay,
prospect of
Yeah.
establishing that it reached a decision on suitability on the review lawfully and therefore withdraws the decision. I'm so sorry to interrupt my learned friend, I should say.
no, thank you.
So in their subsequent minded to letter dated the 26th of May 2023 at page 32 of the supplementary bundle, there's a list of documents which the author says they have considered in reaching their conclusion. The third bullet point is your skeleton argument dated the 15th of September 2022. So there can be no doubt that the argument made by the appellant as to ground 3 was being considered by this review. It's included within the documentation that the review is taking into account.
That could be said to be slightly different. I'm not really quibbling, but the fact that they've got your skeleton argument, the highest you can put it is that because they had the skeleton argument, they knew that in the previous challenge, ground 3 was there.
Yes.
Is that fair?
Yes, that's fair, my lord. So the skeleton argument was before the reviewer, the amended grounds of appeal were before the reviewer, and the grounds of appeal provided, your grounds of appeal provided on the 16th of February 2022. All of that was before the reviewer. Which means that the argument contained therein as to duty was also before the reviewer. But that's right, I can't say that how they felt about the argument, as it were, or that they were persuaded by it. Subsequently, at page 43 of the supplementary bundle.
This is a minded to letter, isn't it?
This is a minded to letter.
32 is minded to.
32 is minded to, and the only there's a reference to it in my skeleton argument because of the size of bedrooms issue. That's addressed at page 40 over to 41 of this document. So, sorry, of this supplementary bundle, which is paragraphs 35 to 36 within this minded to letter. The point is considered there. I only draw the court's attention to it because it's something that's in my skeleton argument. Bedroom 3 was, bedrooms 2 and 3 had been one bedroom and they were partitioned. That's what the judge meant when he found below that there had been a stud wall inserted into that bedroom. The question of suitability focused really on the size of the property and the space for the children to exercise, and that's where the reviewer is considering in more detail than they have before at paragraphs 35 and 36, the size of the bedrooms. However, on 41, when it comes to ending relief duty, the same formula is used, the same error of law is fallen into, and the wording is very similar to the previous decisions that we saw in the first review and appeal process. So the subheading ending of relief duty is just above paragraph 39 on page 41. The same reasoning is evident from paragraphs 39, 40, 41, 42 and 43. Concluding at 43, I'm therefore satisfied that the duty to help to provide you with accommodation has come to an end. This is because not only has the relief duty come to an end, but the main housing duty does not apply. This means you will not receive any further offers. Again, there's no consideration of what, if any, other duties apply under the part. Yes, the disapplication is considered by section 193 capital A, but not the other duties. And significantly here, the duty under section 190 isn't being considered.
So once again, it's silence rather than over express error.
Yes. Well, I say silence is error.
You say it is because in the circumstances it had to be considered.
Yes, it had to be considered in the circumstances, that's true, but also the authorities, and indeed I say the statute, suggests that there needs to be some acknowledgement of the 184 obligation to consider what, if any, duties under the part are owed. And that's what we get in Ahmed in the judgment of Lord Justice at paragraph 62, where there's reference to the use of a subheading saying 184 decision. So I'm saying it has to, my lord, my answer is it has to happen in any event, but certainly on our facts it has to happen, because she has now by this point been evicted from accommodation that she was occupying under the relief duty. I'll now go on to the authorities, but just pausing there to make a purely practical point. At this point in the review process, and the review decision comes next at page 43. At this point in the review process, the appellant has been told that she's been found intentionally homeless, but she doesn't understand necessarily which accommodation that's from, or whether the duty to her that should follow has been accepted or not, and to what extent she's going to be accommodated because of it. In fact, it would seem the duty hadn't been accepted and she wasn't going to be accommodated, even though on the facts she had been told she was intentionally homeless and evicted as such. The significance of that from her perspective is that if left unchallenged, if she's found intentionally homeless, but that isn't made explicit, and that's left unchallenged, and she makes a fresh application, she will have failed to challenge a finding that she's intentionally homeless. And that could be something which would undermine any future application that she might make. So there's the immediate tangible benefit of her not being accommodated and not being advised, as provided for under the section 190 duty. But there's also the risk that in future, a finding of intentional homelessness might follow her and she has failed to challenge it. However, she would presumably say that the reason she had failed to challenge it would be it was never made explicit, but it would lead to a potential risk for her. The only submission that remains to be made on the documents for the appellant's part is to say that the review decision then goes on to repeat what I've said is an error of law in the conflating of the ending of the relief duty with there being no other duties owed under the part. I say that's an erroneous conflation and it fails to give effect to section 184 under part 7, and it's repeated at paragraphs 45 to 49 of the decision under challenge, and that's at page 54 of the supplementary bundle. The same wording is used. There's the same absence of consideration of what other duties are under the part.
All right, can I just want, because you gave a very, very lengthy, quite fast submission to this court before you made that last comment. In this document, which begins at page 32, which is the 26th of May document. Where in that is the assertion that she's intentionally homeless?
There isn't one, my lady.
So what exactly are you saying in respect of that document and the issue of intentional homelessness?
Given that in the previous correspondence she had been told she was intentionally homeless twice in the document of the 21st of January, it would have been proper to put that to her and say whether provisionally there was a duty going to be accepted or not that would correspond to the factual finding of her being intentionally homeless.
Isn't the right way to have done it? I mean, I don't want to get hung up on procedure, but isn't the right way to have done it to have challenged the 21st of January letter?
I suppose that would have been an option at the time.
Well, particularly if, as you say, by not challenging, you run the risk of someone turning around and saying, well, you should have challenged this before. Following it to its logical conclusion, since the document which you rely upon as asserting that she's intentionally homeless, which really gives rise, is a foundation for your entire argument, isn't the right thing to do to challenge that? I mean, I don't know how you challenge it. Ask for a review of the decision that she's intentionally homeless, presumably. But then sorry, I'm thinking as I go, trying to think as I go along, but you would probably say that's a waste of time because this all feeds into the review decision which is coming.
Well, the review and appeal process is already underway. So by ground 3, what duty, if any, is owed.
Okay.
I would say that her position is protected by having made that argument then on appeal.
What was the date of the hearing?
22nd of February 2023.
February.
So
that's after the letter of the 21st of January.
21st of January 22, and then the grounds were filed a month after that, so in February 2022, but it didn't come for hearing until the February 2023.
And then we've got this long gap to 26th of May 23.
Well, yes, that was so after the compromise in February 2023, then it wasn't until the May that the local authority wrote and minded.
The hearing and compromise was on 27th of February 23.
Yes, my lord.
Thank you.
May I just clarify something, which again is gnawing away at me? Your client first requested assistance in April 2019.
Yes, my lord.
I think. It took a couple of years before the respondent accepted the duty to her, the relief duty to her.
My lord, yes.
That's right. And in July 2021, it sent her the personalised housing plan, offering her a 3-bedroom property. Correct?
Yes.
Yeah. At that point, and that was in response to effectively its understanding of its duties under Section 184.
Yes.
Yeah. At that point, was she intentionally homeless?
Well, there was no indication that she was. Nothing was said to that effect.
So, because as I understood it, you're, in a sense, the thing that gets this whole machine moving is the Section 184 inquiry, assessment of her needs, offer of her property, which she then refuses. And at no point up to that stage is she intentionally homeless.
That was never raised. No.
Anybody's case.
There was no any part of anybody's case, as far as I know. In fact, the opposite would appear to be true. Although from memory, when she first applied in 2019, it was from a property called Wren Court.
Yeah.
Initially, the local authority didn't accept that she was homeless, but then they withdrew that decision and accepted that she was homeless.
So she acquired this status of intentionally homeless partway through this process,
It would seem so, yes.
which you say activated the duty on the local authority to actively consider it.
Yes, to actively consider the 190 duty, yes.
But that wasn't around at the outset.
It wasn't around at the outset, as far as I'm aware.
Is it only when there is the refusal? So let me put it another way. Is it only when there is the review decision that the accommodation, which is the offer, the final offer of accommodation, is deemed suitable? Is it then, by reason of the consequences which will flow, that she becomes intentionally homeless, or after that again?
I should, well, it would be for the local authority to apply the test under section 191, but yes, I should have thought upon refusing that offer, she would make herself, well, one version of the reasoning might go that upon refusing that offer, she makes herself intentionally homeless from the interim accommodation. That's the way I'm reading that letter of the 20th of January.
Okay, but let's just jump ahead a bit. Assume for a moment that we decide that the decision on suitability is unimpeachable. Okay. Your complaint is that they didn't go on and say you're intentionally homeless or not. We're going to treat you as being intentionally homeless and owing you the duty ABC or not. How does that lead to a conclusion that we should strike down the decision on suitability? It seems to me that we're heading inexorably to a conclusion where if we're with you, our judgment will simply say they should have dealt with intentional homelessness, but that doesn't affect the rest of the order.
Well,
am I making myself?
Yes, my lord, I understand completely. That I was going to address when I came to the authorities. I say it's a very significant error to have failed to consider what, if any, other duties under the part might arise, and specifically on our facts, for example, whether she had made herself intentionally homeless.
It doesn't cast doubt on the finding of suitability.
But this isn't about suitability. It's about, this case isn't about suitability. It's about duty.
Well,
it's about
you're
duty.
making it about duty, but I'm just trying to work out where it goes. If it's not a case about suitability, and as I read things at the moment, my provisional view is that an attempt to challenge the finding of suitability would never get off the ground, and it's not a ground of appeal here anyway. So what you're either saying, you want a direction of some kind, if we can do it, that they consider and make a finding in relation to homelessness, intentional homelessness, and what they're going to do about it. Or you're saying, because they haven't gone on to think about the duty that they do or do not owe her, as in someone who is or is not intentionally homeless, that vitiates the finding of suitability. And at the moment, that second alternative seems to me to be a very big stretch indeed.
My lord, it's very close. What I'm asking the court to consider is very close to that, but not quite that. It vitiates the decision. It vitiates the decision to terminate her application. It vitiates the decision not on suitability. It just vitiates the decision on review. The review needs to be made again. There needs to be a fresh review. This decision is vitiated by the failure to consider what, if any, other duties applied under the part. I wouldn't necessarily ask the court to make an order that said they must consider intentional homelessness. I would invite the court instead to, if the court was so minded, to make an order that they consider what, if any, duties are owed under the part. I give the example of intentional homelessness because that's what arises on our fact, but my primary case is that, yes, section 193 capital A does disapply the main housing duty, but it doesn't disapply the other potential duties under the part.
If you want us to go beyond the intentional homeless duty, you're going. Speaking entirely for myself, you're going to have to persuade us that there is another duty realistically in prospect, because otherwise we're wasting everybody's time. If there's something which you're not saying should have been considered because it was irrelevant, but somehow vitiates the order. And that's absolutely not a concluded view, but that's how it looks at the moment to me.
Well, I think my lord has my submission on this. My primary case is that failure to give effect to the obligation under section 184 to consider what, if any, other duties apply and give reasons for a negative decision in writing is a serious enough error, a serious enough omission. It goes right to the heart of the function of a local authority in a homeless application, and it vitiates the decision on review. I was going to make good that submission by reference to authorities, which I think will assist the court.
Okay.
But that is my primary position, and then my secondary position is, regardless of the conclusion whether or not the 190 duty applies, it fell for consideration on the facts, and that's a material omission. On other facts, other duties may well apply.
But you're going to look at the law in a moment, and we're preventing you from doing that. But under section 184 1b, that's expressed in the present tense. What duty is owed to him? And I think you used the word a moment ago, potential duty that might arise. And in this particular case, the potential duty that might arise with your client didn't arise, in fact, for a couple of years after the section 184 moment. Am I right? Because section 184, the section 184 decision was 2021, wasn't it? July 2021.
Well, I think the problem is that there's been no clear section 184 decision, and that indeed haunts the...
Well, the inquiry into her homelessness led to the offer of 17 Gretton Road, didn't it?
Yes, my lord.
And that offer was made in July 21.
Yes.
But the intentional homelessness position that you're advocating doesn't arise until
February 22, my lord.
Yeah. So for a number of months after that moment.
Yes.
And it is, and of course, the fact that she refused 17 Gretton Road wouldn't in fact necessarily make her intentionally homeless, because other situations might have come about which might have enabled her to have other accommodation. So it was always ever going to be a potential rather than an absolute certainty.
Yes, I take my lord's point. At that point in time, intentional homelessness coincided, as it were, because the letter of the 20th of January of 22 intimated that she'd found herself intentionally homeless, and she was evicted not until the February.
Yes.
So that all coincided in time, and at that time it would have been only a potential duty. But then a subsequent review was undertaken, which never considered the position, even having evicted her. So in the first instance, one might say, yes, it's really only a theoretical possibility, for instance, that other duties might apply under the part. And that might be to put the position a little too weakly, because in my submission it's clear that in all decision letters at the end of the decision-making process, as in the case of Ahmed, which we will look at, the local authority would usually say section 184 decision, no other duties under the part. It's the conclusion of the review process. But at that stage that my lord's identifying in time, when the eviction coincided with the first review, yes, it was only a potential duty, but still felt, my primary position is still felt to be considered in the rubric of what, if any, other duties apply. So the 184 decision at that point might have said something like, something along the lines of that in honour. We have considered whether any other duties apply under the part, and they don't. Whereas at the second review point in time, on the fact intentional homelessness had arisen, it had been brought up by the local authority's letter of the January, and so at that point the 184 decision would have to be different, because it was no longer just a potential duty under section 190, it was a real prospect. So the 184 decision might have had to say something along the lines of the local authorities considered what other duties arise under the part. We've considered whether section 190 duty would apply, but for whatever reasons we've decided it doesn't, or we say we've already discharged it, or whatever reasons might be given at that point.
All right, now you've had to deal with a lot of interventions from the court. It's nearly 12:10. That clock doesn't work. All right, so you may want to move on to the authorities if you're satisfied you've taken us to the documents you want to take us to.
Yes, my lady, thank you. I begin to address the legal framework at paragraph 39 of my skeleton argument. We've already looked at several sections under part 7. My lord has just taken us to section 184, and it is expressed in the present tense, and the significance of that is something that I will make good in discussing a case momentarily. At paragraph 41, I explain that there are other duties. There's a section 193 duty, the interim accommodation duty, a relief duty, and a short-term accommodation and advisory duty to the intentionally homeless. We've looked at all of those. In my perfected skeleton argument, there's a reference in bold to all the page numbers. I don't propose to take the court to those unless, as we've already looked at them. Similarly, the relief duty, at paragraph 42 of my skeleton argument, there's a reference to the page in the authorities bundle where that can be found. The relief duty and the section 193A disapplication of the main housing duty. At paragraph 43, there's a reference to the guidance, which I would just take the court very briefly to. It is mandatory statutory guidance by virtue of section 182 of the 1996 Act. So under paragraph 1311 of the guidance, which is at page 36 of the authorities bundle, the guidance to local authorities is this: housing authorities may issue a section 184 decision to the applicant that when the relief duty ends, they will owe them a section 190, a duty under section 190, because they have a priority need but are intentionally homeless. Although the section 190 duty cannot commence until the relief duty has come to an end, the authority may wish to alert an applicant that the main housing duty will not be owed. It may be beneficial to review the personalised housing plan at this point to help maximise joint efforts to relieve homelessness. And there's a reference in the subsequent paragraph 1312 to the relief duty, to the relationship between the main housing duty, the section 190 duty arising after the relief duty ends and brings to an end the section 188 duty.
And there's no doubt that she's been a person with priority needs throughout.
She's been held to have reason to believe that she's in priority need and she would qualify for priority need, but there wasn't a 184 decision written.
Aren't we conducting this appeal on the basis that she is a person with priority?
She would be, if for no other reason than the basis she has dependent children, she
Yes.
would be a person of priority.
Thank you.
And then at chapter 18 of the guidance, which is a little further on in the authorities bundle, begins at page 57. There's some guidance given about notifications being provided under Part 7 to applicants, and that's at page 65 to 66.
At 1833 to 1835.
1830 through to 1837. What that amounts to, what the guidance amounts to in practical terms, certainly from the local authorities' perspective, is that it isn't an onerous obligation to write several different letters, all justifying what duties are or are not being accepted as owed under the part. Instead, this can be discharged in a relatively non-onerous way, and that was considered in Ahmed, which is tab 20 in the authorities bundle. Just to take the court very briefly to the judgment of Lord Justice Newey. This was a case where an applicant under Part 7 had applied for accommodation to the respondent, and she had been provided with hostel accommodation, which was provided under the relief duty. And whilst she was in the hostel accommodation provided under the relief duty, the local authority wrote her the decision letter, which was under challenge in this appeal, saying, you are no longer homeless, because we have provided relief duty accommodation. It's available for a certain amount of time, and the statutory duty has therefore been discharged. And at paragraph 20 of the report, which is at page 426 of the authorities bundle, in the judgment of Lord Justice Newey, there's a reference to the further section of the decision letter, which had the heading, Section 184 Not Homeless Decision. So here was a decision, here was an express consideration of what, if any, duties are owed under the part for the purposes of Section 184. It wasn't a long determination. It had a subheading, Section 184 Not Homeless, and it was 4 lines long. And then at paragraph 62 of the decision, the court condones...
Your skeleton suggested paragraphs 55 to 60 or something like that, but I couldn't see that they were really what we were interested in.
Was it paragraphs 47 through to 49? It was about the relationship between the relief duty accommodation,
Possibly.
and the decision to discharge the main housing duty on the basis that she was no longer homeless. So the argument was made that even though she had accommodation which was suitable, it wasn't accommodation which was reasonable for her to continue to occupy. And the court essentially found that that wasn't the case, and that instead it was reasonable for her to continue to occupy that accommodation, even if theoretically it would be possible to remain homeless in accommodation that was available. the court then addressed the section 184 decision at paragraph 62 through to 64. Essentially, the judgment of the court means that what was done by the respondent in this case to discharge that obligation under section 184 was enough. The use of a subheading, and I invite the court to read paragraph 62 through to 64. The use of a subheading and reasoning that referred to earlier factual accounts was enough to discharge the obligation under section 184.
Forgive me, how, apart from a finding of fact that what the authority did in that case was sufficient to discharge their obligations of notification, what do we get from this?
Well, I say that what we get from this is guidance from this court as to what a local authority can do to discharge that obligation. And in contrast to the decision letters that we've been looking at just moments ago, there's silence in the decision letters in this case as to what, if any, duty is owed. There's no subheading, for instance, that says section 184 decision, and there's no consideration of what other duties might be owed under the part. And therefore, there is what I've identified as being an error of law, which is serious enough to vitiate the decision.
But I think the case you have to meet, the primary case you have to meet, is that no decision was made that had to be notified. And the secondary case that is that, but I mean, that's really the secondary case that follows, or the consequence or the danger of that case is that if we find that there was an obligation to say, it's tolerably clear on the facts of this letter that it's not set out by reference at all to section 184, and certainly on your case there is no reference at all to the potential for a home duties owed as to a intentionally homeless person. So I think the case you have to meet doesn't really depend on paragraphs 62 and 64. Although you had a good win in the Court of Appeal that day. Although you didn't.
No, we lost. The appellant lost in Ahmed. It's true, but the court did endorse an approach to section 184, which, in my submission, should be the bare minimum to discharge the section 184 obligation. And here, not even that is done in the decision letter.
So that's it. The court endorsed an approach to section 84, which in your submission represents the bare minimum.
Yes, section 184, 3.
Is there anything more you want to say about this authority? Because you have referred to it a number of times.
Not at this stage. If in response to my learned friends.
Well, let's move to the next authority.
Thank you. At paragraph 46 and 47 and 48 of my skeleton argument, there are references to 3 cases. The case of Anis Minik, the civil service case, and XP Lorno. Essentially, what is the point that is made by the reference to those cases is that the local authority has been given by Parliament a role in making decisions under Part 7. The local authority is charged as the decision maker in applications for homelessness assistance. I don't understand from my learned friend that any of these points made in my skeleton argument, or indeed raised in these cases, are an issue. So unless the court specifically wants me to go to those cases, I won't look at them directly.
No, thank you.
Thank you. Certainly what's considered in the final one of those cases at 49 is reasons being necessary for a decision. Now, there may be no general requirement to give reasons for a decision, but in Part 7, the local authority is obliged to give reasons for their decision, and they're obliged by Section 184, as my Lord has already identified, where there is a determination which is adverse to the interests of the applicant, reasons must be given, and they must be given in writing. That's Section 184. We've already looked at it, but for the court's note, that's at page 4. In the case of South Bucks District Council and Porter, the adequacy of reasons was considered. I'm at paragraph 51 of my skeleton argument. Lord Brown said in that case that the reasoning must not give rise to substantial doubt as to whether the decision maker erred in law, for example, by misunderstanding some relevant policy or some other important matter, or by failing to reach a rational decision on relevant grounds.
I'm not sure anyone's going to quibble about. No.
No, I won't take the court to that authority. In the case of XP Ermakov, the applicant was intentionally homeless, and the reasons that were given in that case, and the reasons for their intentional homelessness, were considered to be inadequate. That authority is at tab 8. At page 220, the obligation to give reasons is addressed by the court in emphatic terms. The purpose is that a person affected by the decision may know why they've won or lost, and in particular may be able to judge whether the decision is valid and therefore unchallengeable, or invalid and therefore open to challenge. That's the final paragraph of page 220. I'd invite the court to read over the page this subsequent 4 paragraphs.
I don't think these principles are really in any doubt.
No. Can I just say this, Miss Murray? And I am conscious you've had interventions from the court, but 1 o'clock is just over half an hour away, and I think it would assist all if you could complete your submissions by 1 o'clock.
Certainly, my lady, I will. The judgment goes on to emphasise the importance of reasons being given with the original decision. There are some passages highlighted for the court's note at page 223 in the decision, and page 227 similarly for the court's note.
We will follow your references.
And I don't think any issue is being taken by Mr. Mullins now.
I'm great. At paragraph 53 of my skeleton argument, I refer to the authority of Nozola Mizo and Westminster City Council. The point is made similarly there by Baroness Hale, as she then was, that it must be clear from the decision that proper consideration has been given to the material.
You've got it.
I won't take the court to that authority. It was said against me, or it will be said against me, that one can read into a decision that things have been taken into consideration by using a generous reading of the decision letter, and that was found to be the case in the authority of McMahon and Watford Borough Council. I refer to that at paragraph 54 of my skeleton argument. However, the judgment of Lord Justice Lewison, and I have highlighted the relevant paragraphs there, is entirely different, although its reasoning cannot be faulted. The reason that Lord Justice Lewison reaches that decision is because what the decision maker is considering is whether an applicant is vulnerable and therefore in priority need of housing, and the error was allegedly that the decision maker had not simultaneously made explicit their findings as to the public sector equality duty for section 149 of the Equality Act. Now, what Lord Justice Lewison says essentially is that the decision maker is tasked with considering vulnerability. Disability is relevant if it to the extent that it would change the position as to vulnerability. So you could be relevantly disabled or not relevantly disabled, as it were, for the purposes of a decision made under section 189. Now, the reason that a decision letter can be read so generously as to say section 149 doesn't expressly need to be referred to is because of the factual overlap that is involved in an investigation of section 189 the 96 Act or section 149 of the Equality Act. So I say our facts are entirely different, and that for a valid decision under section 184, express reasoning was needed.
Right.
Moving on then to, I won't take the court to it, but at paragraph 55 in Nicola.
We can read it. Should we move on now to paragraph 56?
Yes, my lady. In Temor, which is at tab 16 of the authorities bundle, I have highlighted the relevant sections. Essentially, this was a review of suitability and potentially also a review of what duty was owed. I say that the reasoning of Lord Justice Jackson at 32 onwards, as well as the additional paragraph 72 and 73 of Lord Justice Jackson's judgment, in addition to the points then added by Lord Justice Lewison at 74 onwards, make good my point that on review, the local authority needs to consider what, if any, duties are owed under the part, and the point in time when they need to do that is on review, and that's a matter of practicality, and it is the only way that they can safely discharge the obligations under section 184. So I've sidelined those paragraphs. I won't take the court to them in any detail beyond to say that they go up to page 303. So I invite the court to read the whole of the judgment of Lord Justice Lewison in that case. The fact that the relevant date is the review date when the decision is actually taken is highlighted by the case of Robinson and Hammersmith and Fulham. Again, I don't need to take the court to it. I don't think it's a controversial proposition. It's at tab 11, pages 279 to 281, in particular noting paragraph 32.
Right.
Thank you. And what's significant about paragraph 32 is that the reviewer can't ignore an unlawful decision that's gone before. It must be consequential. I say that's highly significant for what should happen following in a review process where it is clear that previously an unlawful decision has been made. The decision maker in that case was criticised because their review should have recognised that the decision maker had denied the rights of the applicants. That's paragraph 32. And the significance was that the duty can't be delayed and it can't be avoided. Briefly then, the case of Ravichandran, which is at Authorities tab 15. I've put a reference there to the page numbers, could I invite the court to read those highlighted paragraphs in the judgment on Ravichandran. What's clear, I say, from that authority is the opposite of what's said against me. So it is said against me that it's for the applicant to say what's an issue in the review. But when it comes to duty, that's emphatically not the case. In Ravichandran, in fact, the court held that put much responsibility on the authority notifying the applicant as to what is an issue and what their rights were and what their opportunities might be for review or reconsideration. Relatedly, although it is jumping a little through the authorities, tab 9 contains the authority of Begum and Tower Hamlets, London Borough Council. Again, I have highlighted sections, and I would invite the court to read those sections which I've sidelined. What's clear though from Begum is at 467 within the report. And I've sidelined it, so it's page 252 of the authorities bundle. The court reasons, and I'd invite the court to read, please, the sections which I have sidelined, but particularly in the final paragraph, the court is emphatic that in relation to the section 184 duty, one can legitimately add to a ground that Parliament will have been thinking of applicants who are likely to be distressed and may well be inarticulate, and the further ground that it will equally have been concerned that public resources should be carefully used. Both point to a requirement no less stringent than in the case of a public planning inquiry, that the local authority must take the applicant carefully through all the factors capable of bearing on the application. Put another way, section 1841 creates a public duty, not a private right. Moreover, since it is a duty affecting one of the most important things in people's lives, the roof over their head, it's one about which the courts ought to be vigilant. Just one final note for one final reference for the court's note. At tab 3, so turning over on my skeleton on page 60.
Tab 3, did you say?
Tab 3 of the authority bundle, yes. Page
Guidance.
Yes, the guidance. My lord asked earlier about the duty that would arise under section 190 and what that might mean. I said there was a reference to the duty in the guidance. It's behind tab 3, page 42 to 43 of the authorities bundle. I've sidelined it.
This is paragraph 15.13.
Yes.
Page 42 to 43.
Thank you.
Yes, 41, 42 and 43. So how that duty under section 190 might be discharged, having been accepted. in conclusion, and I think the court has these points in substance, so I'll be extremely brief. I say that certainly by the time of the second review, duty was in issue and couldn't be ignored, and that in any event it must be considered because that's the statutory function given by section 184 and imposed on the local authority in a homelessness decision. The consequences can't be ignored of there having been an unlawful determination below, must be taken into account on review, and I say that the failure to properly consider what, if any, other duties were owed under the part represents an error of law so serious that it vitiates the decision. I say...
And just forgive me for interrupting you again, but the way it would work on your submission is we would quash or identify the error of law, namely the failure to deal with the intentionally homeless duty one way or the other, assuming that's where we go. We would then, it would then be for the local authority to carry out the review for a third time, and if, I suppose the consequences would be, if they said no duty as an intentionally homeless person, you could challenge that. But the end result on you having told us that they didn't in fact discharge any duty to her as an intentionally homeless person, at least until 24, she would then have a claim for something, would she? Because I mean, otherwise it's a complete waste of everybody's time.
Well, she could be accommodated. Well, I mean, my primary position is it's an error of law so serious it vitiates the decision. But my secondary submission is that it is material because it's an accommodation duty. She could be accommodated for 6 weeks, 8 weeks with her children and provided with advice relevant to the local area as to how else she could obtain further accommodation.
What now if we would set aside the review?
Yes, if the local authority reviewed its decision and said they owed her a duty to the intentionally homeless. All that matters is that they turn their mind to what other duties are owed under the part, because the error that they've fallen into, which is clear from the structure and clear from the silence, is that they've conflated the ending of the relief duty and the disapplication by 193 capital A of the disapplication of the main housing duty. They've read that to mean that no other duties apply under the part when that isn't the meaning of the statute.
Okay, but as I'm sorry to be so slow, but the way it would work is the authority would have to carry out another review. You would hope that by this time they would have got all your points on board. And the one that matters, because let's assume they're not going to change their finding on suitability, the one that matters is whether or not they owed or were prepared to accept a duty to her, either as a person who's intentionally homeless or not. And at the end of that review process, they either come out and say, sorry, no deal, or no duty, in which case, theoretically, there's a scope for a challenge to the county court again on that. Or they say, yes, we should have found, or we do now find, or both, that the duty, we owed a duty to her, or we accepted a duty to her as a homeless person, either intentionally or not, with priority needs. And then the practical effect of that would be that going forward, that would reset the starting point, is it? She would then, as from the time of that review, what I don't get at all at the moment is what we do about the interim period, or what anybody does about the interim period.
The interim period that's already passed.
Or the period that's gone.
Yes. Well, it'd be for the local authority to decide. It would be extremely valuable to the applicant to have a finding on intentional homelessness either way.
Going forward.
Yes, whether she could challenge it, whether she could challenge the provision of accommodation that followed from it if it was accepted, whether she could follow the advice. If nothing else, a period of accommodation would be very valuable to an applicant of this sort.
And I think final question on this from me, possibly, but I don't give any undertaking, is that there is a process clearly going on at the moment, because we've seen the November 24 letter. How does that impinge on any of this?
For our present purposes, what's clear is that she's still homeless. That's been accepted between the parties. I can take instructions about where that's up to in terms of what it might mean, but if this appeal succeeds, then her current application, I suppose, would, in theory, would be superseded because a new review would be carried out.
Miss Murray, I was going to invite you in any event to turn your back on the court to see if there are any other points that are required to be made. Not that I'm saying you haven't covered everything, but given my Lord Justice Stuart-Smith's specific questions, do you want to turn your back now to see if there's anything on that point or anything else?
Yes.
I personally don't think there is a question she wants to ask about a new minded two letter of intention that she got in December, but I think we can talk about that at lunchtime. I think that's relevant.
I haven't seen that. My lord, I'm told there's a letter that I need to look at over lunch in the new review proceedings. I can't comment on it now because I haven't seen it. But in my submission, it would all be superseded by whatever happened in this. If this appeal were to succeed and the local authority was required to conduct a fresh review, that would supersede what's happened subsequently in terms of a fresh application. That would be my submission. There are no, apart from that, I need to look at the document over lunchtime. There are no other comments or submissions that are made from my lay client or my solicitor at this point. Unless I can assist further, those might just.
I'm done. I'm so deaf I can't hear you. Just for a minute.
We're just going to rise for a couple of minutes.
Court rise in favour.
It's horrible when they're badging you.
Well, I suppose you have a plan of what you're going to say.
You only get punched in the face, that's what they say, isn't it? That survives first contact. I mean, it was the same for me last week. I was left alone for
I meant to ask you.
30 seconds. Yeah.
Tell me about it.
In a good way, I think actually with me, but if they could help themselves interrupting all the time.
Why are we whispering? Have they gone or are they coming back?
They're coming back.
So they're coming back. I don't know why they're going out. I essentially think they're considering they don't need to call on me. I don't know. It might be that, which I'd be surprised about. But I can't think why else they'd need to
rise of fable.
Thank you.
Miss Mary, Mr. Mullin, there is a point which is exercising the court, and it is this. There is no challenge to the suitability decision. We've got your point on section 184, we've got your point on section 190, but to what might be called the core decision, namely suitability, there is no challenge, and certainly I will offer my provisional view, there couldn't be a challenge to the suitability decision. What happens thereafter in the letters is a different matter. And what we are minded to do now is rise to allow you and Mr. Mullin time, and we'll be coming back at 2 o'clock, to consider what the position would be if, for example, the court were minded to find there is force in the section 90 argument and a failure to address the intentional hopelessness point in any review decision, where then the court goes in respect of the substance of the suitability decision. All right? It's a slightly more refined point and a narrow point, and I'm not asking either of you to give an immediate answer because there are practicalities as well, and certainly give each of you a chance to talk to each other about it.
For what it's worth, Melody, I think I probably can give the local authority's answer now, but I'm happy
No,
to.
not yet.
Very well.
No. Go away, think about it,
Very well.
and we'll start again at 2 o'clock. Nothing more you want now?
No.
Steve? So thank you, Ms. Murray. We've no additional questions from the court. We'll run it now and we'll come back at 2 o'clock.
Court rise of fable.